Good afternoon and welcome to the Level 22 panel discussion on the prospect of a statutory civil action for invasion of privacy. I have with me this afternoon, very excitingly, two professors of law at the University of Sydney, Professor Emeritus Barbara McDonald, and I also have Professor David Rolph. And as well as that, I have defamation and media law barrister Matthew Lewis, also from Level 22 Chambers. We are being live streamed this afternoon on YouTube. If you have any issues, please send an email to our clerk, Jackie Charles, at clark@level22.com.au. If you have any questions, which we'll address at the end of the panel discussion, please either email Jackie at the email address that I've just given you, or just submit them on YouTube chat, and that would be wonderful. Now, Barbara McDonald served in 2013 through to 2014 as a Commissioner of the Australian Law Reform Commission in Sydney, where she headed the inquiry into serious invasions of privacy in the digital era. Their remit was to design the detail of a statutory civil action for serious invasions of privacy and to make other recommendations about how the law could prevent or redress serious invasions of privacy. David is an academic member of Level 22 Chambers. He has served on advisory committees for the Australian Law Reform Commission on privacy, and very excitingly, this week, David published this gorgeous and important book on contempt, and even more gorgeous is the fact that it is dedicated to Barbara, who is also here.
Who witnessed its writing.
Yes, exactly, and possibly went through the pain of it as well, vicariously. And also, the foreword is written by the Chief Justice of the High Court, Stephen Gageler, which is even more exciting. So we commend that book to everybody. Of course, and Matthew Lewis practices from Level 22 Chambers and also Doughty Chambers in London. He regularly acts on behalf of traditional mass media as well as new media at first instance and on appeal. Matt has also represented many notable social media platforms, so this topic of privacy is of particular interest to Matthew. Now, the reason we are here is that the federal government has agreed in principle recently to the introduction of a statutory cause of action for serious invasion of privacy. First of all, Margaret will give us an overview of the key aspects of the Australian Law Reform Commission's design. Following Barbara's overview, we will explore as a panel what a statutory cause of action for serious invasion of privacy might offer potential plaintiffs and mean for potential defendants. Over and above the following potential causes of action, we'll deal with breach of confidence in equity. We'll also deal with defamation, and also one of my favourite ways of dealing with this sort of case is misleading or deceptive conduct based upon companies' published privacy policies on their websites. And also we will deal with common law torts, such as trespass, wrongful interference with goods, nuisance, and from overseas, a very delightfully named intrusion into seclusion from New Zealand and Canada, and misuse of private information in England. But without further ado, Margaret, if you could give us an overview. Barbara, sorry.
Not at all. Good. Thank you very much, and thank you to Level 22 for inviting me to come and talk about this. It was really interesting to see the Attorney General announce that the government supported, in principle, the recommendations of the Law Reform Commission from our inquiry, which finished in 2014. Between 2014 and 2023, various other people have looked at it and made recommendations, the Productivity Commission, the ACCC, and then most recently there was another inquiry by the Attorney General's Department as part of its review of the Privacy Act, which is another world in itself of data protection, of course. What I should note is that when the Attorney General announced the government's response to the department's report, he noted that they supported the introduction of the ALRC design in principle, subject to looking at further safeguards to protect public interest journalism. And it's that latter point that I'm really interested in getting some views from here as to how that could happen. But first I need to explain just exactly what our design was. We were given a very specific brief of matters on which we had to make recommendations, and all I'm giving you here are the elements of the cause of action in the next slide. The elements of the cause of action. Now you can see there's quite a lot there, but of course the report also goes into defences, limitation periods, remedies and so on, all of which we were asked to make recommendations about, and there are also other ancillary recommendations to deal with young people and so on. So these are the key elements of a proposed statutory cause of action. Firstly, there must have been an invasion of privacy, either by intrusion into seclusion or by misuse of private information. There are many other different ways that privacy can be affected in some way, but we picked on those two because we felt it was better to be specific about the sorts of conduct that had been the subject of actions in other jurisdictions and that were the examples usually of egregious invasions of privacy. And of course, if you set out certain methods, they can always be added to if thought appropriate. I mean, one of them, for example, would be appropriating somebody's image, which is one of the classic Professor Prosser torts that he mentioned in America back in the 60s. But, that would require a lot of discussion about overlap with intellectual property and so on. So we left that one to one side and just picked on these two. Secondly, the tort would only be actionable where a person in the position of the plaintiff would have a reasonable expectation of privacy. Again, this is a threshold, I suppose, if you like, or a test that has been used elsewhere. There is a higher test, which is that the invasion would be highly offensive to a reasonable person. But bearing in mind other elements, we felt that the reasonable expectation, sorry, I need to go back to the other one. The third element is that it would only apply to invasions of privacy that were intentional or reckless. Again, limiting it. Now, this is an important limitation. It wouldn't therefore apply to merely negligent behaviour, and it certainly would not be a strict liability, which is what some of the submissions had hoped for. The invasion must be serious. That was part of our remit, but in line with defamation reforms, I think nobody wants to see the courts distracted by trivial or minor issues. It must be serious. Now, given all of that, we recommended that the tort be actionable per se, in the sense that actual damage, as in economic loss, personal injury, psychiatric illness or property damage, rather weirdly, should not be required. And that also means that, as in a case of assault or battery, false imprisonment, mental distress is compensable. We thought this is important because most invasions of privacy in these circumstances lead to mental distress rather than anything else. They might lead to economic loss, and of course that would be recoverable, but usually mental distress is the problem. And then finally, and this is a really important, I can't emphasise enough how important this next point, actionability element is, and I emphasise it particularly to any media representatives or interests listening tonight, that to be actionable, the court must be satisfied that the public interest in the plaintiff's privacy outweighs any countervailing public interest. This distinguishes the design of the cause of action from, for example, a defamation action, where the plaintiff has a complete cause of action when they prove a defamatory statement that's been published and thus the likelihood of serious harm. But then the onus passes to the defendant to to establish a defence. This is something that's built into actionability, so that right up front, the court is going to need to be satisfied that any privacy outweighs public interest. If we look at the next slide, we can see that in terms of some of the factors, again, we felt it was better to be a little bit more specific in terms of guidance. We recommend guidance to people interpreting a statute rather than leaving it to the courts to spend 20 years interpreting it. We suggested some factors relevant to a reasonable expectation of privacy that the court might take into account, but there might be others. The nature of the information, the means used, the place of the intrusion, the purpose of the use, how the information had been held by the plaintiff beforehand, to what extent it was already in the public domain. I mean, this is obviously often a killer for a breach of confidence claim. We don't see that as being fatal to a privacy claim, because if information is private in nature, it may remain private in nature, even though you can look it up on the internet and see pictures of somebody coming out of the shower. I won't say who to further invade her privacy, but that was an example. Relevant attributes of the plaintiff, age, etc., conduct of the plaintiff, any prior conduct in publicity, and so on. And then when we turn to the next slide, which is the factors relevant to public interest, again, we specifically thought it was better to set out some matters of public interest. I mean, we certainly talk about that as being matters in the balance in the report. Freedom of expression, a specifically separate item of freedom of the media to responsibly investigate and report us on matters of concern and importance, administration of justice, open justice, public health and safety, national security, and in the context of some discussions actually that have been happening today in Parliament, in Senate committees, prevention and detection of fraud and crime, because as we all know, it's extremely important now with identity theft and the various scams that information, this is obviously a great public interest that has to be weighed up. So we felt it was better to list some. We did have a round table in London in 2014, the beginning, we were still working on the discussion paper and then the report. And we had various barristers and solicitors from the English bar, and also a couple of the judges, Lord Justice Steadley in retirement, and Justice Tugendhat, and whether or not we should list the matters. And they said, no, leave it to the judges. And the barristers and sisters all said, no, give us some guidance, please, about, what this is meant to be doing. So that was an interesting contrast. So that's really the overall design of the cause of action, but with particular emphasis on that last hurdle, if I may describe it that way, of actionability. And that might be the background then for some later discussion, Cynthia, on some questions to think about.
Yes, indeed. So we had two questions for the audience to think about, and then we'll come back to it at the end. So you have some time to form some considered views. So the first question is by reference to this fourth slide. Given the Attorney-General's indication that further consultation is required to protect public interest journalism, what types of safeguards, in addition to or in substitution for the ones in the Australian Law Reform Commission's design, so having regard to this fourth slide, might be appropriate? And then if we could just go back to Barbara's second slide.
Yes, it's really about that last point here.
Yes.
So what would be a better safeguard for public interest journalism than that? And I'm really interested in any ideas.
Yes. No, that's and the second question is based on your experiences with your own practices, to what extent do settlements in breach of confidence or related actions include an amount for mental distress? So has that happened in people's experience? So we'll come back to that at the end. But what we were next going to look at was, I'd mentioned that there are these four different groups of potential causes of action at present in the law. And we were going to explore, first of all, breach of confidence in equity, and the extent to which there might be gaps there that need to be filled by a statutory cause of action, and what implications having a statutory cause of action might be for the various parties. Matt, if you could kick off to start with.
Of course. So in Australia, most of the people in this room and online will probably know all too well, privacy is protected in Australia by way of an equitable remedy of breach of confidence. That has at least 3 elements to the cause of action, possibly 4. Firstly, that the information obtained is of a confidential nature. Secondly, that it was communicated or obtained in circumstances where the confidence was imported. And thirdly, that there's been some sort of, and this is quite important, I think, for the discussion, that there's been some sort of unauthorised use or misuse of that information. There is an arguably 4th element to the cause of action, which has caused some consternation in Queensland, I think, of note. But that is whether or not there should be any detriment caused to the claimant or the plaintiff seeking the relief. In a privacy context, that's been used in a number of different ways in Australia. In recent times, I can think of at least 3 good examples. Firstly, to protect reputational harm and distress, picking up the point that Barbara just mentioned, following the dissemination, and that's an important point, the dissemination of sexually explicit images. And there's a number of different cases involved with that, which a lot of people will be familiar with. 3 of them would be Giller and Prokopitz, Wilson and Ferguson, and of course, Scala and Scala. And secondly, more recently in the Ben Robert Smith litigation, it was used to prevent the tender of a diary of person 17 in the middle of her cross-examination. And thirdly, to prevent dissemination by the media of financial information obtained by reason of the Panama Papers. So those are 3 recent examples where breach of confidence has been used in this country. Of course, there are some criticisms of the use of breach of confidence to protect privacy in particular. It's not necessarily doing what it says on the tin, so to speak. In the UK, there is the misuse of private information tort, and that specifically protects privacy. Breach of confidence is something somewhat different, and there's been some academic argument about this in the past. And of course, whether or not we're shoehorning, as it was described in recent judgments in the UK, an equitable remedy or rather a tortious remedy into the equitable remedy of breach of confidence. There are some shortfalls with the use of breach of confidence as a remedy. One of the obvious examples, I think, which has been touched upon already, is what's been classified in other countries as intrusion into seclusion. And by that I mean, for example, like the voyeuristic behaviour that Barbara mentioned a moment ago, or perhaps in another context, using your employment to obtain information. In this particular case, I have in mind financial information, purely to check on whether or not someone else has been paying child support. And so there's no dissemination as such of the information. Another good example is perhaps an unauthorised strip search, something along those lines. And in each of those examples, there's no dissemination, there's no publication. And so what's the remedy? Breach of confidence requires there to be some sort of misuse, as I said earlier on. And so as a result, there's some sort of anomaly in the equitable remedy, at least, to try and protect someone's privacy. And so there's an obvious shortfall in that regard. One observation, as opposed to a criticism, that I'll make from recent times in the UK is a practice has subsequently developed over the course of the last, I'd say, 5 to 10 years, probably closer to 5 years, where claimants in the UK will plead as a cause of action misuse of private information, breach of confidence, and also in the UK the breach of the Data Protection Act, all to protect the same underlying complaint. And so the reason why they do that is because breach of confidence in the UK has to be heard and determined by the High Court. It can't be determined in the county court. And so claimants generally tend to plead breach of confidence to try and take it into the High Court to have it determined there, and then all the other actions fall underneath it. But of course, in more recent times, the Data Protection Act is the relief of choice, should we say, for most claimants. That's led to an increase in strikeout applications by defendants. It's led to severe delays in determining the complaint, and an increase in transfer applications from the High Court to the county court. And there's been a string of recent authorities from the High Court, including Mr. Justice Nicklin, the judge who's in charge of the Communications and Media List in London, whereby that practice has been criticised. And so now claimants have to elect what cause of action that they would like to plead and have the matter determined in accordance with. That usually means that breach of confidence in certain circumstances, especially the trivial cases, goes, because it has to go to the district judge they're sitting in the county courts. The equivalent in Australian terms is, of course, the district court. And then I did wonder, just before this seminar started, as to whether or not a similar complaint perhaps might be made in an Australian context. And I looked at the New South Wales District Court Act before coming on to check out and to remind myself rather of the equitable jurisdiction. I don't think that's likely to happen, interestingly, in at least New South Wales anyway, because the equitable jurisdiction applies in the district court only insofar as a damages claim has been made. And I think if a breach of confidence claim was filed in the district court, I don't think you'd have the same sort of issue that I've just been foreshadowing in the UK. But it'd be interesting to see how, if this comes to pass, this statutory tool, whether or not there might be a practice of a number of different causes of action being pleaded by plaintiffs or an applicant if it's in the federal court, and how that might transpire in the course of time in terms of transfer applications and strikeout applications, especially in relation to trivial cases.
Well, it's certainly up till now. I mean, without a statutory tort, I mean, you'd have to be a pretty brave plaintiff to be arguing for further development of privacy without the statutory tort. I mean, and presumably plaintiffs who have a breach of confidence action would much rather go with that as an established cause of action than follow the High Court's invitation to develop further protection of privacy.
Some have given it a go, though, of course. In Doe and ABC, for example.
Yes, yes.
Other cases, like it's not. It has happened.
It has happened.
Few and far between. Yes, must be said.
One thing that flowed from what Matt was mentioning is the metes and bounds of unauthorised use of the information. So Matt suggested that, well, look, if there hasn't been a dissemination of this information, then it's not unauthorised use. And I just thought that's interesting. Is that by reason of the way that the courts have interpreted it narrowly? Or?
Well, I think traditionally breach of confidence has been about the breach of the confidence, you know, of telling the story, telling the secret rather than collecting the secret. So there is a bit of law on whether or not you can use it for just collecting or looking at private information, which is what some of the Canadian cases have been involved, you know, snooping in somebody's bank records and things like that on a regular
Because I'm sort of thinking in terms of use, that you snoop in someone's banking records and then you can use it to, I don't know, in your negotiations with them because you know that they're just a person of straw. So you can go harder or something like that. So,
it'd be hard to prove, that's the trouble, wouldn't it?
Yes. Yeah. But no, that's did either of you have comments on breach of confidence?
Well, I think, again, there is a significant difference, you know, I think between something that's private and something that's confidential. I mean, we do seem to have got away, I think, from the requirement in breach of confidence that it must have been imparted in confidence, so that there seems to be a recognition now that the very nature of the information, like somebody's diary or an unsent letter or something like that, can be confidential even though they've never imparted it to anyone. So that's good. But, you know, there is the problem, it's that, you know, I think private information is just often different in nature than something that has been created as confidential. It's just private because it's private. So that is the difference. And the other thing is that there is no, in Australia anyway, no defence of broad public interest for breach of confidence. So, and courts are very ready. I mean, David can talk on this more than me, but courts are very ready to give injunctions for breach of confidence. You know, it's part of equity's exclusive jurisdiction, and you can get an injunction to restrain a breach of confidence very easily, whereas it would be very different, I think.
Yes, because confidential information is like an ice cube. So if you don't, that's the Sir John Donaldson sort of metaphor that, if you don't protect it in that way. I think that's right. I think the public interest, absence of a public interest offence, I think, is a problem from a defendant side. So you just have the old iniquity defence, which is very difficult to establish. And so that gives very broad protection for plaintiffs, but makes it very difficult for defendants to ever sort of justify in circumstances where there might be a public interest in publishing. The other difficulty, and you see this particularly in the UK, where you've seen the metamorphosis of misuse of private information out of equity into a freestanding tort, is in equity, public domain is a complete defence. And that, I think, is really where you get that tension between privacy and confidentiality. So if you see in a case like PJS and News Group newspapers, the UK Supreme Court there very clearly says, well, it doesn't matter that lots of people know throughout the world who PJS and his husband are. An injunction actually has some work to do because that can prevent further intrusion, and public domain is not a defence to misuse of private information. The problem, of course, is using breach of confidence as the means of protecting personal privacy is that you've still got that commitment to public domain. So as soon as, the information is out there in the public, it loses any ability to be protected. Whereas, privacy, I think, is something different in kind from that. And so that's why I think having a sort of cause of action that deals with that more directly is important. The other thing which I think is a difficulty is that the heads of damages that you might get if you wanted to seek equitable compensation are more limited in equity, so for breach of confidence. And we see this in Giller and Procopets, where because breach of confidence is an equitable cause of action, you can't get exemplary damages. But if you've got an intentional intrusion upon someone's privacy, people might expect or think that that might be a case which warrants the court to sanction that conduct. And so that's obviously something that you can't get through a cause of action in breach of confidence.
Yep. Those sort of damages, though, for it's a moral wrong, isn't it, essentially? So they're quite low in comparison, though, to other awards in other jurisdictions. I mean, I think I can't remember what it was now in Gilbert, it was less than, I think, 40,000, I think. And Wilson Ferguson's around about the same. And then I think in Scala it was 70,000, I think. So, and then in the New Zealand case was probably even much less. I think maybe, I can't remember, but I think it was 30,000.
I can't remember how much it was. I mean, there are very interesting cases in the UK with the assessment of damages for the various phone hacking claims. And what was interesting there was that the early claims for the new breach of confidence, new tort of misuse of private information, quite modest damages really. But then once a certain media company started to settle, claims for phone hacking in the tens and hundreds of thousands, I think it was Justice Tuppendale himself who said, oh, well, you're upping the ante a bit here about what it's worth when you've hacked somebody's phone. So that might have a flow-on effect. Settlements may have a flow-on effect to the amount that the court might award.
True.
No, it's, so perhaps we could move on to defamation. And David, do you want to make some comments about that?
Yeah, I mean, the interesting thing about defamation and privacy is that I think there's not terribly significant sort of gaps that privacy could fill. So the one sort of area that I think people have talked about defamation filling is the sort of false light sort of tort, where the statement is not really defamatory, but it casts the plaintiff in a false light. And so that's one of the sort of four torts identified by William Prosser, which is the sort of one of the gaps in the sort of the legal protection. Quite often you'll hear sort of assertions in defamation cases that privacy is a value or it's indirectly protected through defamation, which I think is less common now. So one of the ways that you could see defamation indirectly protecting privacy is through the defence of fair comment. So by the requirement that you can only comment about something that's a matter of public interest, that then says you can't gratuitously invade someone's privacy and then sort of discuss it publicly. And interestingly, the English courts had to sort of relearn all of that in the context of misuse of private information over the last decade, where they sort of had all of those sort of debates about that in the context of privacy, completely forgetting that those debates have been had in relation to the defence of fair comment in the 19th century. What I think is really interesting about defamation and privacy is the overlap is that if you introduce some greater form of privacy protection and that then becomes sort of the cause of action that people want to pursue, it then has potential consequences for defamation, which is a very broad-based, well-settled cause of action. And it may actually require you to rethink some very basic aspects of defamation, which we think are very well settled. So the two areas which English courts have grappled with, varying degrees of success, is the restrictive approach to injunctive relief in defamation. So in the late 19th century, when courts became able to grant injunctions for defamation, the view was taken that you should very rarely be able to get an injunction. There's a discretion, but it's very rarely exercised in defamation. That was at a time when there was no real recognition of any right to privacy. And so you could publish something, and so long as it was true, even if it was grossly invasive of someone's privacy, that wasn't a problem. Now that you've got, in the United Kingdom, a greater protection for privacy, that rule in Bonnard and Perryman has had to be sort of reviewed, because defamation turns on an axis of truth or falsity, whereas privacy turns on is it private or not. And they don't sort of intersect very neatly. And the problem, of course, with something like defamation and privacy is that they protect interests which are essentially aspects of the plaintiff's persona, their public self and their private self. So the same publication can implicate both reputation and privacy. You can't sort of draw very niche conceptual distinctions, although people tried to from time to time. The other thing which is becoming increasingly a problem is if you have a cause of action for invasion of privacy. Historically, we've thought of defamation as the principal cause of action where you get damages for damage to reputation. But English courts are now completely concerned about to what extent can you provide protection for reputational harm through an action for invasion of privacy. And so because privacy is something that can overlap with defamation, you have these very difficult sort of issues which actually cause you to have to rethink some of these really basic sorts of aspects of defamation law. And one of the things I think about a reform process, a law reform process, is that you can actually sort of sit down and think about those sorts of things in advance rather than trying to do that on a case-by-case basis over, what, now almost 20 years. So the problem, I think, posed by the interaction between defamation and privacy is a sort of knotty one. And if we do go down that path, I think they're probably some of the major problems that will arise.
I think that's very interesting, the point about the fact that if there's a statutory recognition of the right to privacy, the impact that has upon Matt's clients, public interest journalism or investigative journalism. Did you want to chip in about?
Well, I mean, to the extent that the talk might kick off in Australia, the concern, I think, from the media's perspective, as I'm sure Barbara would be more than familiar with, is that it might actually have a chilling effect on journalism.
Yeah.
And one of the things I just picked up actually in respect of the slide actually was the test as to whether or not it's actionable, that the court must be satisfied that the public interest in the plaintiff's privacy outweighs the countervailing public interest. And then obviously that there's some sort of permutations in there of open justice. And when one has regard to the Court Suppression on Publication Orders Act, for example, the test there is whether or not it significantly outweighs. And it would appear that the word significant has been omitted, at least here, and so there might have some degree of watering down of the test, which might have a chilling effect.
Yes, yes. No, that's interesting to sort of add even with the balancing to. I mean, I suppose the word again. We were not able to do exposure draft of legislation, which I think is always a bit of a problem because we all know that a word can make a big difference. So I think the idea is that you have to be able to show that the privacy interest is weightier than the countervailing public interest, whatever that is, like open justice or proper investigation of things. Perhaps that is a proposal, that it would have to be significantly, in addition to everything else, it has to significantly outweigh any countervailing public interest. And that's a good point, that it could be, it could be, the balance could be predetermined a little bit more by that sort of word. You're absolutely, I mean, of course, to me, the big issue for the media, I mean, frankly, it's not some of the issues that we've seen discussed on TV sometimes about, footage of people shagging in a public toilet in in some bar somewhere, but rather much more important matters such as disclosing the identity of someone who's under investigation. And that's what the English media have come up against. And those are the points that the media here have pointed to in objecting to this idea. So the Cliff Richard case, where he was very successful and got damage to reputation because, the BBC or somebody had been tipped off that the police were going to come and raid his home. A couple of others, an arrest of a terrorism suspect, the Bloomberg case involving financial misdealings and so on. And that really is a very difficult issue, but it wasn't just the subjects who were complaining about the possibility of public exposure. It was also the law enforcement bodies who were getting involved as well, because they knew that if it was out there that they were investigating somebody, that could have a real impact on the integrity of their investigation. So that's really to me one of the most difficult issues for the media, and it's a serious matter. It's not a trivial, gossipy sort of nonsense that we have to worry about. And I do think that is the difficulty. And look, I mean, yes, I also admit that our defamation law is hard enough. I suppose that one point I would make, certainly I keep emphasising the Australian Law Reform Commission had no interest in shutting down public interest journalism, and it really is a matter of, with a design, what is an appropriate balance. And short of an exemption for the media, what is the best way? But that's an interesting point of actually putting a little bit more weight.
One thing, I mean, you'll forgive me for saying this, but
Yeah.
When I'm involved in suppression or non-publication orders, or resisting them usually, one of the things that I've noticed, and I'm sure a lot of other practitioners would share this view, is that prior to the 2010 Act, applications would have been perhaps less scarce than they are now. And Section 6, of course, of that Act gave primacy to open justice. And if a similar approach is used in this situation, my strong intuition is that, like in the suppression case, there's going to be an exponential increase in these applications being raised, notwithstanding that you're giving primacy to public interest journalism. And that's one of the things that I'm alive to, and I think some of my clients would be alive to.
Yes, I can imagine. I mean, look, I suppose the whole point is that was it Jeremy Bentham or someone who said that, once it's in a statute, every person can be a lawyer, so they can see it. So it's more visible for everybody, rather than finding their way through judgments to see what rights they have. So look, undoubtedly that could well be an impact, as you say. It seems to be the impact of the suppression laws.
Well, I think as Richard Ackland would say, these orders are being handed out like confetti.
Well, no, they're wonderful observations. And then the next cause of action that I'll briefly touch upon is in the privacy space is the ability to bring a cause of action for misleading or deceptive conduct. And I actually had a case where my client was in what had become quite an acrimonious employment dispute, and someone, a very high-level executive at a publicly listed company in Australia, wanted to help out his friend who was in this dispute with my client, went onto his computer and they collected a lot of highly confidential private information about various individuals, went onto the database, copied and pasted it into an email, sent it to his mate, and then his mate used it against my client. So what we did is I thought, look, I'll write the letter of demand and it will probably end very swiftly. And so we just said, look, you have a privacy policy on your website. You say that you're going to do X, Y, and Z, and my client had a reasonable expectation that that would actually be adhered to, which, given the nature of the information these people collected, it was really obvious. And we sent that letter, and the reason I went for misleading or deceptive conduct is that if the letter didn't work, then I think the first case management hearing before a judge in the federal court probably would work, or they would want to not have that experience of it being uncovered. And yes, it did settle extremely quickly after we sent the letter of demand, and it was a very good result for my client. It's interesting in terms of the mental distress element, because that was very, very high.
Was it?
And he and his wife, who was also somehow involved in this dispute, it was very, very hard for them. I think we may have put in the letter, and there is this mental distress element. But anyway, it certainly was a good result, and he's doing very well now, and I see on LinkedIn, so we're all okay. So anyway, so that's one sort of work around the fact that because with that case, I looked at the Privacy Act and saw, look, it really is a toothless tiger, and thought, well, but how can we use it? How can we use the fact that these people have to have these policies? So that was a one way of doing it that worked out. Does anyone want to comment on misleading or deceptive conduct?
Well, I suppose, I don't know whether Section 18 and the provisions on damages in the consumer law mentions mental distress. I mean, it doesn't mention mental distress, but nevertheless, nothing wrong with asking for it.
No, exactly. Well, and I think probably they opened the checkbook and said, look, go away. So, right. And then I think, Barbara, you're going to address us on common law torts.
Yes, well, look, this, could be a few hours of lectures. So.
No, exactly.
You haven't signed up for it, and I know you all have homes to go to. So, look, we all know, we've got trespass, we've got trespass to person, trespass to goods, trespass to land, nuisance, and there's been quite a bit on privacy in nuisance in the Tate Gallery case in the UK Supreme Court, quite famously recently, where Tate Modern was held liable for nuisance because they built a platform which looked into people's apartments nearby where they had floor-to-ceiling glass walls. But what was really important there was that Tate Gallery had built this viewing platform, and it enabled hundreds or even thousands of people regularly to go and peer into these people's apartments. So the law of give and take, it was held that it was a nuisance, and caused a lot of jumping up and down amongst, I must say, English academics. We weren't so particularly surprised because we've had cases of personal intrusions. I think we had a case called Rossetti and Hughes years ago where Justice Young gave an injunction, interlocutory injunction, where somebody in Roseville, a quiet suburb of Roseville, had set up a camera and lights whenever the plaintiffs went out into their backyard, their neighbours' lights and action would come on and film them. So he had no trouble giving an injunction. The Court of Appeal were a bit dismissive of that decision, but the UK Supreme Court cited it with apparent approval. It was a case of snooping and interfering with their use of their property, so it was squarely within nuisance. The problem is, of course, that common law torts, have gaps. They develop very slowly. So, for example, to trespass the person, you've got to actually touch the person or threaten them or imprison them or something like that. Photographing them is not, will not normally be sufficient. Trespass to land, title to sue is very important. I like to think of the case of Kay and Robertson, Gordon Kay from Allo, who was lying in his hospital bed when two paparazzi from the Sunday Sport came in to take a photograph of him for all his fans and put it in their newspaper. And the best the English Court of Appeal could do at the time, much apparently to their regret later, was to say, well, there's an injurious falsehood here because they're implying that he gave consent when he didn't. But situate that in Australia, what would be the position? And it does happen. I remember, seeing some poor victim from one of the Christchurch earthquake being carried on someone's shoulder, and she was saying, "Don't film me, don't film me." Well, we were watching her saying that on national television, and then the journalist went into her hospital room the next day. So I think that's quite a good measure, whether we have sufficient protection of privacy for that sort of intrusion, and I don't think we do. Wilkinson and Downton, I think, could do more work. Intentional causing of mental distress. Now, the only judge in Giller and Prokopets who was prepared to extend the Wilkinson and Downton action on the case for willful injury to mental distress was Justice Maxwell in Giller and Prokopets. The others all used, by analogy with tort, which wouldn't give a remedy, they used the analogy with tort to give a remedy in equity, which was a little bit of a jump, but probably fine. So I think Wilkinson and Downton could do a bit more action. If serious distress is actually intended, then what is the problem? And if the High Court in Lino Gay Meats said one way of developing more protection of privacy is to develop existing actions, then perhaps we should take up that invitation, and it wouldn't be such a massive jump as the jump of introducing a statutory action. The media have been very strong in saying, no, it should develop by the common law. But of course, in Smethurst and Australian Federal Police, there was no allegation of invasion of privacy to allow Anita Smethurst to get back the unlawfully obtained data after an invalid warrant. And that would seem unfortunate to me, because that would have gone a long way to actually supporting trespass as a reasonable protection of privacy and people's data, which had been unlawfully seized by the Australian Federal Police. But they were so concerned not to plead privacy protection that they didn't take up the opportunity for themselves. So look, I think there's still a lot of work the common law could do, but it needs a courageous, a well-resourced plaintiff, I suppose, and a courageous representatives.
And then courageous judge. And I suppose and the High Court has made that clear, that
they have.
The common law evolves slowly. Yes. And so the judges who have been activists have been wrapped on the knuckles for it. So, so I don't know, David, what's your observation?
Yes, look, I think the Wilkinson and Downton thing is a sort of interesting way of developing, and that might offer some prospect. The problem, of course, with some of those established torts, as Barbara points out, and particularly, trespass to land and private nuisance, are that they're land-based, and so not only do you have sort of title to sue as a problem, the invasion of the intrusion upon your privacy has to occur where you have that possessory interest, and so we all leave our houses. We're all here. And so, there's work for those torts to do, but it's limited, I would have thought. So I do think that those sort of broader-based torts like intentional infliction of mental distress would probably have more work to do, I would have thought.
There are some instances where that tort has been pleaded of recent times, but they don't get to trial. They end up sort of settling well before trial.
Yeah.
But I was thinking, you just reminded me actually, Barbara, with your analogy with the photographs of the case of Candy and Bauer Media, where which actually did, I think, exactly what you were talking about, which is where there's been some sort of element of privacy anyway, where I think in that case it was Holly Valance, wasn't it, who was out on the yacht, and she was heavily pregnant at the time and didn't want to be photographed, to your point. And I think Bauer Media had a photograph of her with a long lens. Went to be published, and I think the only issue was that stopped the injunction anyway was the fact it was going to be futile, because the magazines had already been loaded on a truck and had been heading out to the distributors.
Yeah, that's right. Yes. Well, she should be able to get mental distress in those circumstances, I would have thought. That might be a start.
But breach of confidence has work to do in that situation.
Yes, it does.
Which is
Has work.
the point I was trying to, because that was
exactly.
the course of action.
Yes. I mean, one of our other recommendations in another chapter was that state courts should be amended to actually specifically provide for damages for mental distress in certain cases, subject to public interest and so on. But nobody was interested in that chapter. It was chapter 13. I didn't get that. We did very well.
But I suppose with the common law torts, there are the land-based ones, which are the ones that have been litigated in Australia. But then there are these overseas options to import the intrusion into seclusion idea, and then also the in England the misuse of private information. So a courageous judge or a semi-courageous judge could look over to overseas.
I mean, yes. The trouble is that the platform for that to develop in the UK was the European Convention on Human Rights and the Human Rights Act of 1998, which directed public authorities, including courts, to give protection. So that was a platform which we don't have. We're signatories to the international covenant, but when we don't have any protection. But again, I suppose I'd point out to the argument that we got often, that there is no legislative protection of public interest, is that we were recommending legislation that would recognise public interest and the importance of public interest journalism. But having said that, I know that public interest is in defamation, and it doesn't have, it's not always successful.
Only recently, in some respects.
So
we might be able to ask the audience for any comments on Barbara's first question, which was additional safeguards for protecting public interest journalism. Matt's come up with the word significantly, which is interesting. Good idea.
I have a comment about that, which is that the label public interest journalism is question begging. And in defamation, the case law has developed a series of tests, but there's a concept of what kind of journalism is in the public interest in the defamation context.
yes, yeah,
Where, as David pointed out, the axis is truth or falsity. And so at a very high level of generality, we see journalism in the defamation context as being in the public interest, where it makes a decent stab at publishing things that are true, using reliable sources, seeking corroboration, seeking comment from the plaintiff, those kind of steps.
But they'd have to be more than true, wouldn't they? They'd have to be true and about.
True. But my point is, in that context, there's a notion of what this involves. And as David pointed out, the axis is different when we're talking about privacy.
Yes.
And I think in legislation, there might need to be some explication of what we mean by public interest journalism, because I don't think it's particularly helpful to invoke this as a label as though it's self-evident that any particular kind of publication is public interest journalism.
Yes. Perhaps if I could, Jackie, could we just go to that one further down, the next slide? Keep that one, yes. Particularly to responsibly investigate and report matters of public concern and importance. Does that go some way, or can it be better?
This is a debate that's been had in defamation now with the Section 29A defence. where one school of thought was you look at the public interest mainly in terms of the subject matter. So in the Russell and ABC case, the ABC's argument was this is reporting about alleged war crimes, and that should be the judge's primary focus, whereas the other side of the debate was you still have to pay attention to the characteristics of the particular article that was published, and whether this particular article, regardless of the subject matter, is in the public interest given how it came into being. And that was the argument that won the day in Russell. And I think that may be a debate that we have to have in this context as well.
Yeah, no, thank you. That's very, very interesting. Anybody else online or, in person for any solutions? Possible safeguards. But and then there was Barbara's second question about including an amount for mental distress
in breach of confidence cases, because as we've often said, we academics see cases when they come to judgment. We don't see settlements. So we don't know, other than by occasional rumour and discussion and anecdotes, what's going on behind closed doors, particularly when there are non-disclosure orders and so on. So I'm just interested to know whether Giller and Prokovitz was in 2008, Wilson and Ferguson, and the other case you mentioned, Scarlett. How common is it? You mentioned mental distress in
my letter,
case. How common is it for people to add in mental distress amounts in a breach of confidence case? Yes, I mean, I'm not leaving defamation to one side, but in pure breach of confidence.
I mean, it's probably quite unusual in the sense that it's going to be difficult to quantify it. And so I think that would be the...
I have one or two breach of confidence cases a year, and I think in all of them we've only ever had injunctions. There's never been, apart from costs, there's never been monetary settlement.
I had one recently, I think I mentioned it to you the other day, which I'll tell everyone what the issues were without revealing the parties' names because the rules are suppressed. But there was a lady who was of a certain ethnicity who had engaged in an extramarital affair. And the person that she was having an extramarital affair with had uploaded unbeknownst to her. So the argument was the explicit content to a pornographic site, and that had been syndicated and went around the world and had been viewed over 60,000 times. And it turned out that she had a daughter who then had to help delete that content, or try and assist in deleting that content from around the world. That involved a lot of mental distress because it involved the breakdown of a marriage. It involved her coming clean to her husband and her daughter. It involved the breach of trust at the time with the person she was engaged in an extramarital affair with. And then having to go to court and instruct a team of lawyers who all had to see the content in order to
advise.
And so there was a lot of delicacy, if I can put it, around that. And I know the junior who worked with me on that case is watching online, and she was responsible for having to watch some of that. But that did end up settling for a certain sum of money, which I can't disclose. But it did involve an element of distress because that was something that was of particular importance to the client. And I've had one like Nick. I mean, I've had a couple of these sorts of cases a year, and mostly they're involving an injunction. But there are those sorts of Wilson and Ferguson, Giller and Prokovitz type cases out there, which don't see the light of day because they're all suppressed. But which do have that element of it. I mean, I'm quite surprised that they're not as prevalent as I thought, because in a day and age where everyone has a smartphone, we all have smartphones on the table, where things can be surreptitiously recorded and you don't necessarily know it. With an age where people upload social media content without thinking and sort of, without the benefit of pre-publication advice. I'm quite surprised
Yes.
that there aren't that many cases, but I'd be surprised if distress didn't creep in and inform the award of damages.
Right.
But then, like I said before, I mean, the amount of damages anyway for these sorts of cases are actually comparatively small.
They are, yes, they have been.
So, you know, I think you have to take a global perspective of it, but certainly distress informs it.
Yeah, no, that's excellent. Did you have a comment, David, or no?
No.
No. Okay. Well, I think we can wrap up. Thank you all very much for tuning in and coming along. Thank you to the wonderful panel. Excellent.